The trial chamber considers that at this stage of the proceedings, it has a large amount of evidence, which will be mentioned more specifically later. This evidence would allow any reasonable trier of fact to conclude beyond any reasonable doubt that the crimes alleged under count 1, relating to persecution as a crime against humanity, and under counts 10 and 11, relating to deportation and forcible transfer as crimes against humanity, were part of a generalized attack against non-Serb civilian population with the goal of expelling them from the territories of Slavonia, Baranja, and Western Srem, from the municipalities of Zvornik, from the region of Sarajevo, from Mostar, Nevesinje, and from some parts of Vojvodina in Serbia. Therefore, there is no need for the trial chamber to examine at this stage of the proceedings to the question of knowing whether these facts were committed in the framework of a systematic attack. Secondly, the trial chamber will now give examples of evidence that could support the fact that each crimes alleged in counts 1, 10, and 11 of the indictment were committed, and that the attack against the non-Serb civilian population was of a generalized nature. Number 1. As far as count number 1 is concerned, i.e. persecution, a crime against humanity, the trial chamber would like to recall first, as stated in paragraph 985 of the media appeals judgment, that the crime of persecution is an act or an omission which introduces a de facto discrimination and which refutes or violates a fundamental right recognized by the international customary law or by the conventional law, and which has been deliberately committed with the intent to discriminate for an unlawful motivation, notably to discriminate on racial, religious, or political grounds. However, any act of discrimination does not equate to a crime of persecution. The acts underlying persecution, making up a crime against humanity, be they in isolation or jointly with other acts, must present the same degree of seriousness than the crimes listed under Article 5 of the statute. Furthermore, even though persecution often implies a series of actions, a single action may be enough as long as the act or the omission is discriminatory in fact and was deliberately perpetrated with the intent of discriminating for an unlawful reason. Therefore, as stated by the appeals chamber in the Kordic and Cherka's appeals judgment, murder, mistreatment, unlawful attacks against civilian property or individuals, the illegal detention of civilians, the destruction of civilian property, and plunder are elements of persecutions similar to which can be equated to a crime against humanity when they are either when they're taken in isolation or jointly with other actions. To establish that there have been persecutions as elements of a crime against humanity, it is necessary, in addition, to prove that the perpetrator of the underlying actus reus had a specific intent to discriminate for unlawful reasons, notably on political, racial, or religious grounds. The required discriminatory intent cannot be directly inferred from the general discriminatory nature of an attack qualified as a crime against humanity. However, the appeals chamber, in paragraph 110 of the Cordic and Cercas appeals judgment, considers, and I quote, "The discriminatory intent can be inferred from such a context, subject to the existence, as far as the facts are concerned, circumstances surrounding the commission of the crimes alleged, which confirm the existence of such an intent." In this case, the persecution alleged in the indictment aimed to expel non-Serb population from a number of regions, i.e. Slavonia, Baranja, and Western Srem, from the municipalities of Zvornik, of the region of Sarajevo, of Mostar, of Nevesinje, and of certain areas of Vojvodina in Serbia. The trial chamber also notes that the elements underlying persecution as referred to in the indictment mainly correspond, as far as time as far as time is concerned and the location is concerned, to the crimes alleged under the other counts, i.e. deportation and forcible transfer as crimes against humanity, as well as murder, torture, inhuman cruel treatment, destruction, and plunder of property protected by the Geneva Conventions as crimes of war. There are also other underlying acts of persecution as alleged in the indictment. There are other acts such as the application of restrictive measures and discriminatory measures towards non-Serb civilians, and public and direct denigration in speeches made in Vukovar, Mali Zvornik, and Hrtkovci, promoting hatred of Croats, Muslims, and other non-Serb populations. The trial chamber notes that the accused denies all allegations under count 1 relating to persecutions. The accused notably challenges the allegations of religious discrimination and states that he never gave any speech in Mali Dvornik in 1992, that no speech was delivered during the war in Vukovar, and that during his speech in Hrtkovci, in the framework of his electoral campaign, he only supported the idea of an exchange of civilian population and the principle of retortion. Therefore, the accused submits that the Croats left in the framework of voluntary exchanges of property and not in the framework of a campaign of persecution aimed at expelling them. The accused also specifies that in the assumption that the deportation and forcible transfer would have been recognized, these crimes would not reach the necessary intensity to be sanctioned as persecution as referred under Article 5 of the statute. The trial chamber cannot take into consideration this last submission, which is totally unsustainable. Apart from the fact that, as far as the generalized nature of the persecution of non-Serb population, the trial chamber had a large amount of elements, the seriousness, notably of the deportation and forcible transfer, also results, obviously, from the provisions of the Geneva Convention of 1949. Article 49 of the Fourth Convention bans forcible transfers, be it en masse or individual, as well as deportation, as well as expulsion of protected people outside the occupied territory to send them towards a territory of the occupying power or to the territory of any other state, be it an occupied state or not, and for whatever reason. This provision is mentioned again in Article 85 of Additional Protocol 1 to the Geneva Conventions for International Armed Conflicts, and in Article 17 of Additional Protocol 2 to the Geneva Conventions in case of domestic armed conflict.
The trial chamber specifies, moreover, that in the statute the term deportation in English has been translated as expulsion in French, and that this crime is expressly provided for as a crime that can constitute a crime against humanity under Article 5 in paragraph D of the statute. The appeals chamber, in the appeals judgment Cornelius, held that the crime of persecution may take on different forms. It may be one of the other acts that make up the elements of the crimes charged in Article 5 of the statute, or one of the acts that make up the elements of crimes in other articles of the statute. One can therefore not challenge the fact that expulsions and forcible transfers may constitute underlying acts of the crime of persecution when they are committed individually or cumulatively with the requisite discriminatory intent. As regards actus reus of the underlying crimes of persecution alleged in the indictment, the trial chamber will analyze these hereinafter pertaining to the commission of crimes charged under counts 4, 8, 9, 10, 11, 12, and 13. Therefore, the chamber shall now address, and only address as an example, some of the evidence it has on the commission of persecution that would allow a reasonable judge to support, at this stage of the 98 bis decision, the fact that the perpetrators of the underlying material acts had the requisite discriminatory intent. Before I continue, I would like to mention that I'm going to quote names of witnesses and exhibit numbers. Since there are many of them, there might be some names of the witnesses that are misspelled, and some figures may be recorded incorrectly. This will be corrected at a later stage. The registry will have the document I'm reading from and will check that the names and the exhibit numbers are correct. So if there are any mistakes, don't worry about it. These mistakes will be corrected. I shall endeavor to read this out slowly. As regards the existence of a campaign of persecution against the non-Serb population in the municipality of Zvornik, the Chamber refers, for instance, to witnesses Fadil Banjanovic, VS 1064 and VS 1066, that testify to those facts, on the basis of which the Chamber may infer that the specific criminal intent existed. As regards evidence on the imposition of restrictive and discriminatory measures against non-Serb civilians, including restrictions of movement, removal from positions of authority in local government institutions and the police, dismissal from jobs, denial of medical care, and arbitrary searches of homes in the municipality of Mostar. The Chamber refers, as an example, to witnesses VS 1068, VS 1067, and to exhibits P658 under seal, P659 under seal, P1052 under seal, who testify to these facts, and on the basis of which the Chamber may infer that the specific criminal intent existed. As regards the municipality of Nevesinje, the Chamber refers, for instance, to witnesses Ibrahim Kujan and Vojislav Dabic, and to exhibits P524 and P880 under seal that testify to facts of the same nature, and on the basis of which the Chamber may infer that the specific criminal intent existed. As regards the area of Sarajevo, the Chamber refers, for instance, to witnesses VS 1055 and VS 111 and exhibit P456 under seal that testify to facts of the same nature, and on the basis of which the Chamber may infer that the specific criminal intent existed. The specific requisite criminal intent existed. As regards the Vojvodin, the Child Chamber refers, for instance, to witnesses Alexa Ejic and Katica Paulic, who testify to facts of the same nature, and on the basis of which the Chamber may infer that the specific requisite criminal intent existed. Now, as regards counts 10 and 11, on expulsion of non-Serb civilians as a crime against humanity, and on the forcible transfer of this population as an inhumane act and a crime against humanity. The trial chamber notes that the accused argues that in Herchovsky inter alia, but also in other municipalities, the departure of the non-Serb population occurred as part of an exchange of property, allowing for the possibility of staying for those who so wished. The trial chamber remarks, furthermore, that the accused indicated on page 16694 of the transcript that at his speech in Herchovsky, he had promised that when he would come to power, he would see to the exchange of property and would apply the principle of retortion.
Que l'interprète serbe.
I waited because the English interpreter was faster than the Serbian interpreter. On this point, it is important to recall that according to the Appeals Chamber in paragraph 229 of the Kornelat's Appeals Judgment, the trial chamber cannot infer that there is a real choice because consent was given, insofar as the circumstances under which it was given may deprive it of any value. Accordingly, the evidence received by the chamber that mention a consent must be reviewed in their context, bearing in mind the situation of insecurity and the climate of fear that prevailed, the threats and other forms of violence, the fear and the vulnerable position of the persons in question. Therefore, it is a lack of real choice which is important in determining the unlawful nature of expulsion or forcible transfer. In the present trial, the Chamber considers that the fact that the accused tries to substantiate resorting to expulsion and forcible transfer of non-Serb civilians as relevant because this would amount to legal retortion measures under international law. The trial chamber shall now provide a few examples of the evidence which is sufficient to base its analysis to consider that the crimes charged in counts 10 and 11 were in fact committed in the various municipalities mentioned in the indictment. As regards the municipality of Vukovar, the Chamber refers, for instance, to the testimonies of the expert Anna Maria Radic, of Dragutin Berghofer, and of Vesna Bosanac, and to exhibit numbers P278, P587 under seal, and P632. As regards the municipality of Zvornik, the Chamber refers, for instance, to the testimonies of Fadil Bajanovic, VS 1012, VS 1013, VS 1064, and to exhibit numbers P663, P664, and P665. As far as the Sarajevo area is concerned, the Chamber refers, for instance, to the testimony of Safet Sejdic and to exhibit number P463. As regards the municipality of Nevesinje, the Chamber refers, for instance, to the testimonies of Goran Stoparic and Ibrahim Kuyan, as well as exhibit number P524. As regards Vojvodina, the Chamber refers, for instance, to the testimonies of Alexa Ejic, VS 1134, VS 061, and to exhibit numbers P537 under seal and P564 under seal. As regards war crimes now alleged in counts 4, 8, 9, 12, 13, and 14. Firstly, as regards count 4, namely the murder of non-Serb civilians as a violation of the laws and customs of war. The trial chamber notes that the accused challenges the murder of some people in Velipromet, and he seems not to admit the existence of the alleged crimes committed in the municipality of Zvornik, save for the murder of 20 or so men and young Muslim boys and Croatians from Bosnia, for whom the accused underscores that this should be attributed solely to Arkan's men. The Chamber shall now provide a few examples of the evidence which is sufficient and on which it can base its review to consider at this stage of the 98 bis procedure that the crime of murder charged under count 4 was in fact committed in the various municipalities mentioned in the indictment. As regards the municipality of Vukovar, the Chamber refers, for instance, to the following evidence. As regards the execution of non-Serbs by the Serbian forces on an execution site located between the Ovčara farm and Grabovo, close to Vukovar, on the 20th of November 1991, the Chamber heard the witnesses VS 016, VS 007, Emil Sakalic, as well as Davor Strinovic. The Chamber has also received the exhibits P609, P611, P615, P782, and P786. Furthermore, as regards the evacuation of the Vukovar hospital and the execution of some of the prisoners at the Velipromet warehouse, the Chamber has heard the testimonies of Dragutin Berghofer and of witness VS 051 and has received exhibit number P282. As regards the municipality of Zvornik, the Chamber refers, for instance, to the following evidence. On the murders committed at the Ekonomia farm and at the Siglanar factory, the Chamber has heard the testimonies of witnesses VS 1015 and Fadil Kopic. Furthermore, as regards the murder of the Bosnian Muslims at the Technical School of Karakai, the Chamber has heard the testimony of VS 1012. As regards the murder of the detainees at the slaughterhouse of Gero, the Chamber heard witness VS 1066. As regards the murder of Muslims committed at the Cultural Center of Drinjača, the Chamber heard witness VS 1064. As regards the area of Sarajevo, the Chamber refers, for instance, to the following evidence. As regards the execution of non-Serb civilians killed at Leševo in the municipality of Iljaš, the Chamber heard witness VS 1111. On the murder of non-Serbs in Zuč in the municipality of Vogošća, the Chamber heard witness Safet Sejdić. As regards the municipality of Mostar, the Chamber refers, for instance, to the following evidence on the murder of non-Serb civilians at the Vrapčići Stadium. The Chamber heard witness Redzep Karisic and has received exhibit number P418. As regards the execution of non-Serb civilians at the mortuary in Sutina, the Chamber has heard witness Fahrudin Bilic. Lastly, regarding the municipality of Nevesinje, the Chamber refers, for instance, to the following evidence on the murder of men whose bodies were found at Telesha Lastva. The Chamber heard witness VS 1022 and has received exhibit number P523. Now, as regards counts 8 and 9, namely torture and cruel treatment, as a violation of the laws and customs of war, for which the prosecution alleges detention and confinement under inhumane and brutal conditions of non-Serb civilians, including forcible labor and sexual assault and violence. The trial chamber notes that the accused challenges the allegations of forced labor in the municipality of Vukovar. The accused admits, furthermore, the allegations of sexual violence in the municipality of Zvornik, but holds that these incidents took place at the end of May and at the beginning of June of 1992. According to the accused, therefore, before the volunteers of the SCP or the SAS were present in the area, which would mean that the accused could not be held responsible for these sexual assaults. The Chamber will now provide a few examples of some of the sufficient evidence it bases its review on to consider at this stage of the 98 bis proceedings that the crimes charged in counts 8 and 9 were in fact committed in the various municipalities mentioned in the indictment. As regards the municipality of Vukovar, the Chamber refers, for instance, to the following evidence. As regards detention and confinement in brutal and inhumane conditions of non-Serb civilians at the Velepromet warehouse, the Chamber heard witnesses Dragutin Berkofer and VS051. On detention and confinement under brutal and inhuman conditions of non-Serb civilians at the Ovčara farm, The chamber heard witnesses Vojnovic and VS 016. I shall now make a break, because we need to have a break. I have read approximately half of the trial chamber's decision. We shall have a 30-minute break. I would like the registrar to turn off the air conditioning, which is above my head, because I will be frozen solid before the end of the hearing otherwise, and I will be unable to speak. My voice will then be totally frozen. We shall now have a 30-minute break.
All right, we will have it.